Wow. Okay. Whoa. We're gonna turn that volume down. I don't like the sound of my own voice that much. Ladies and gentlemen, we are. I'm going to go ahead and begin the Juvenile Justice meeting. Call it to order. These are for hearings only. There is a sign-up sheet up here. Have we retrieved the sign-up sheet yet? Okay. There is a sign-up sheet up here. If anybody, any member of the public would like to speak on either of the bills that the committee has before it, either Senate Bill 167 or Senate Bill 225, please sign up. But otherwise, that's going to be retrieved. Going once, going twice. Okay. All right. We're going to, these are for hearing only. Members of the committee, there is going to be a late arriving substitute to Senate Bill 225. So we're going to start off with Senate Bill 167. Senator Brass is going to give us just kind of a brief overview of the bill. I had received a lot of public comments, and I see we have a number of members of the public that have signed up to speak. So we're going to hear that. We will then table the bill, and we are meeting again on Monday at 1:30. So Senator Brass.
Thank you, Madam Chair, members of the committee. Thank you for having me here today. Presenting SB 167, and just real quick, what we're doing here is we're really trying to encourage family members in the case of a foster child, really just kind of early ID and engagement of that family member, trying to get them to come to the table a little earlier. And if they don't, we're simply giving the foster parent a little bit more preference when deciding the permanency of that child, because as we all know, the stability of that child of staying in a familiar environment, staying in a loving home, is really our ultimate goal. And I think that's kind of got lost through the years in search of these family members. And and you're going to hear some testimony of cases where you've got a distant relative this in some cases never even seen or met the child, showing up 2-3 years down the road and taking the child from that loving home that they're already in, that stable environment they're already in. So really all this bill is simply just we're giving the department a little bit more direction as to when they can stop the search for the family. Federal law still will require that search to remain open, but the active search, we are giving the department a little bit more guidance as to when they can stop that active search, and really just kind of forcing the family members to come forward in a timely manner. So.
Thank you so much. Members of the committee, any questions? Chairman Ostration.
Thank you. I'm not sure which one. Thank you, Madam Chair. I didn't see my light come on. Thank you, Senator, for bringing the bill. I was looking at the bill as passed in the Senate, and then I'm looking at the substitute that you're presenting here today, 480098S. Could you just summarize for me maybe the differences between the bill as passed in the Senate and the substitute and the reasons for the changes?
Sure. So the original language, and we've got Director Rawlings here. He can probably speak to that a little bit better than me. But essentially, what it is was the original language did exactly what we wanted it to do, and it was. But we brought his legal counsel looked at it and decided to really kind of strengthen it a little bit and really give the department a little bit more direction. As to when they can stop that search for the family, and in fact, if there's even some language in there that to where the department can be held accountable if they place a family member, or if they place that child with a family member when they really shouldn't have. So it gives that a little bit of teeth, and then also it just kind of when a juvenile judge is looking at the criteria to determine that permanency, I believe there's, and you can help me, Director Rawlings, I believe there's 10 to 12 items that they're looking at to determine that, and so we're strengthening a couple of those things that they look at.
Okay, for clarification, I'll recognize Director Rawlings.
Okay, thank you, Madam Chair. Chairman Stretch, I know you're familiar with all the federal requirements. So essentially, it was redrafted a little bit more in line with the federal terms of reasonable efforts, et cetera. So I believe the intent and the extent of the outcome for both, there's 3 operative parts. After 6 months, the court can determine that this is a good placement, essentially. After 12 months, the court can determine that removing that child from a stable foster home would not be in the child's best interest. And the third part that was actually added from a bill last year that was just kind of stalled a little bit, was there has been in the code an odd requirement that I think was misplaced. That requirement said that after terminating parental rights, the court should then look for a relative. And of course, the way we have structured our code and our federal law in the past 15 years, we look for relatives up front. If we don't have a relative identified by the time we get down to the TPR, that's not the time to do it. So we're simply saying that instead, at that point, the child should be placed for adoption or permanency in line with the factors that are important, including the best interests of the child, placement stability, the attachment of the child to family and to foster parents.
Okay. May I ask a few follow-ups real quick?
Sure.
All right, Director, I just want to make sure I'm understanding this. It just looks to me, of course, just reading the sub now, it looks like we're going from really a presumption or the ability of the court explicitly, and the bill is passed in the Senate, to consider the foster placement after that 6 months has passed, to really give that foster placement the same type of treatment that a family member would otherwise give. And it seems like in lines 40 to 44 here, what we're really saying is it's just not, we're just removing the requirement after 6 months. And there's a distinction there. Is that because of federal?
That's a distinction to make sure that this is in the courts. We want to not run afoul of the federal requirement. We have to keep looking for relatives regardless.
Yep.
Okay, it's a separate requirement. Even if a child were adopted, if we can continue to look for relatives along the way, we may be able to let the adoptive family know, by the way, there's an Uncle Billy in Kentucky, and maybe one day you may want to get back in touch with him. So we keep looking for relatives, but we need to sort of separate the idea of continuing to look for relatives from giving the court the authority to say, look, this is a good placement. We need to kind of continue down this foster care placement road, and after 12 months, you better give me a really good reason to remove this child, or else this is what we're going to do.
Okay.
So
The election ability, or I guess the judge can consider the child's desires.
sure.
And so that's not in the substitute.
I'm not sure that made it into the substitute. I think it's still probably a general principle of what we do. We didn't have it in the substitute itself, but I think when you look at the federal law and our other code, the child over 14 years of age already has a say in his or her permanency plan, so that should take care of that.
I know we're just here for a hearing today, so
Yes,
I'll
sir.
just express my thoughts on that. Sometimes in a dependency case, the child might not even be in the courtroom, and I know the child will have an attorney there,
Right.
but I do think it's important. I liked how the bill out of the Senate said the judge shall consider the desires of the child, and then as far as the 12-month requirement, it's really similar to what we were discussing earlier, right? It's just removing the rigid requirement,
Right.
and simply saying the judge has a greater ability.
ability.
Okay.
And as these ladies, we have a number of foster parents here, and I've been hearing from, well, let me kind of give you a couple of personal stories. Back in 2004, I got reversed by the Court of Appeals. I had a TPR case. I had some really good foster parents who had had this child for 2 years, and literally Uncle Billy, his name, came out of the woodwork of Kentucky at the TPR hearing. And I said, look, I'm just not going to consider Uncle Billy as a placement. These children are already well adjusted, et cetera. And the Court of Appeals reversed me on that one part of 1511-321 because I didn't consider him. So that's why we're removing that. The other issue is that we have seen that because our caseworkers take to heart the idea of continuing to look for relatives. Sometimes we have seen unfortunate situations in which there has been a move to place a child with a relative who showed up a year, 18 months, 2 years after the child was already well adjusted and happy in a foster home. And I'm not going to speak for Senator Brass, but as far as that age thing, it's, you know, I see where you're coming from on that, and I think
I'll just maybe make one final comment. I'm very grateful for the Bill Center. I'm grateful for your passion and work on this, and of course, Director, I appreciate you. I really think that there are foster placements many times where foster parents are really doing an outstanding job with a child,
right.
And the discovery of a family member later in time could actually be very detrimental.
Yes, sir.
And the ability of the court to do what's in the child's best interest is very important. But I am sensitive to the requirements that we're under as well, and that we have to consider in drafting here.
Certainly.
So, thank you.
Thank you.
Thank you. Representative, did your question get answered? Okay, all right. Chairman Cantrell. Oh.
There we go. Okay. Director Rollins, I just want to kind of follow up to what Chairman Estration was asking you. So are you saying that, in effect, whether it says the judge shall consider or may consider, that in practicality we end up at the same place? Because if he or she can, they will?
So we're giving a little bit more freedom and direction to the court, but mostly also we're sending a signal to our own staff. So it's always good, I think, if you can encourage judges and our own staff, because they read the statutes too, and they create their placement plans and their case plans in accordance with what the statute says. So by saying may and then shall consider, the judge is still going to do what the judge finds is in the best interest of that child. But it's a matter of, and of course this is coming from y'all, the General Assembly. The General Assembly says we want to make sure that you're weighing these factors of placement stability and whether or not a relative has made the effort and whether or not the child is really bonded with a foster parent.
Okay. Follow up, Madam Chair. Senator Brass, this is more of a comment than is a question. Very grateful for you bringing this bill. I like the direction we're heading in, and I want us to continue to look at these issues. The church where I serve has a massive foster care ministry. We fostered over 100 children in Cherokee County in the last just year. And so I'm hearing from foster care families all the time about these kind of issues, much further than this. But this is a huge step in the right direction of allowing our court system to do things that are in the best interest of the child, in my opinion. And I would like to see us do more in the future about addressing TPR concerns and the whole way that, that whole process, if there were a way of expediting that in certain circumstances where it's appropriate, instead of starting the clock over and over and over again with the same parent. I know you know what I'm talking about. So
thank you, Chairman.
Thank you for your help.
I'm on the same page with you, obviously.
Thank you.
One bite of the apple at a time.
All right, thank you. Ladies and gentlemen of the committee, do you have any other questions? Representative Oliver.
Senator Brass, do you mind if I ask the Commissioner a couple other questions?
No, ma'am, you go right above me.
I support this
Literally.
bill. I support this bill. I want to say the 14-year-old decision should be put back in if we move forward with it, or their view of it. I'm trying to remember, and I don't remember. I thought the statute or the regulations had a time limit that already gave direction to caseworkers. You shall look, your relative search shall be accomplished within X days or Y days. And the second question is, to the extent y'all understand your compliance with the 15 to 22 month thing, does this bill help that or kind of work away?
This bill helps that tremendously. And
thirdly, do you still have a policy that foster care parents have to declare at a certain point that they wish to adopt?
It's a little, honestly, it's a little up in the air right now. We have traditionally asked them to declare at some point, But I think that honestly, given the focus that has been placed on relatives, that I think we've kind of gotten away from this. I think we're going to be going back to more of that, because obviously the purpose of this bill is not only getting the relative to come forward, it is also whether or not that foster placement is stable and is one that is likely to result in a permanent placement. So we need to look at that. On your first question, the diligent search must be filed within 30 days.
That's what I thought.
The court is supposed to review the diligent search at every hearing. Again, I'm afraid that what happens is whenever you give nice, well-meaning people who work in a bureaucracy sort of guidelines, that sometimes they're not sure how to apply those guidelines, especially when they may be a little bit conflicting. For example, the stable foster parent versus the recently come forward relative. So we're just trying to make sure that that's clear in the law and we can develop policy around it.
I thought I remembered the 30-day requirement.
Yes, ma'am.
So I'm supportive of this, but and you're assuring me that this is not in conflict with any of the federal mandates that you're required to follow.
I had the best experts in Georgia look at this. Yes, ma'am.
Okay.
And there's not in conflict.
Thank you.
And I would say that if someone were to want to add back in that specific amendment that was from original bill regarding the specifically asking the child, I'm sure that I don't want to speak for Senator Brass, but I bet he would probably be okay with that too.
I would. And just to be clear, Representative, when he said experts, he wasn't referring to me.
There used to be a policy where the foster care parents were in two categories: one you could adopt and one you couldn't adopt.
Right.
And that's all gone now, I guess.
It's gone, and
Okay.
but we need to look at it again. So.
Okay. Thank you, Representative Oliver. Representative Hutchinson.
I have a quick question. Thank you. I remember being involved in a case very similar to what we're talking about, and it was the foster parent had the child for many years, and a grandparent showed up after 4 or 5 years, and I advocated for the child to stay with the foster parent, but the department's position was that statistically, the parent, if a child is taken in by a blood relative, that statistically the rate of adoption disruptions were lower with a blood relative. Is that something that y'all still believe, or?
I won't quote Mark Twain here, but statistics are sometimes. I will say this: if we can place with a relative very early on, then that statistic is absolutely valid and absolutely correct, which is why we are on a path now as an agency to avoid removing the child from the extended family if we can help so. So in other words, keep with Grandmama or Aunt Sally or Aunt Shelley or whatever. And then, but I think the dilemma we run into is that when the child has already formed that long-lasting bond with a foster parent and then it's disrupted by someone who does not already have an attachment to the child, then that statistic no longer applies.
I agree, and I like the bill.
All right. Thank you. Any other questions from the committee? All right. Thank you. Thank you, Director. Thank you, Senator.
Madam Chair.
Now we're going to have some public comment. First, I'm going to recognize Jennifer Shinpo. Okay. I was thinking that was anyway, I thought it was an H.
The CH is silent. Hello. My name is Jennifer Shimpo, and I've had the great privilege of being a foster parent for 6 years. We have adopted, fostered, and have biological children as well. Their ages are 2, 4, 5, 6, and 8. I am the Foster Parent Association president for Oconee County, and I'm an advocate on behalf of foster parents. After many sleepless nights and dwelling on the horror of children being ripped out of foster families, my husband and I began work last August petitioning lawmakers like yourself who would make changes to our laws for our children in foster care. Senator Matt Brass graciously met with my husband and I and became the voice for Georgia's children. Today we meet to talk about our most vulnerable citizens, children in foster care, and in 2016, an article by Cassie Bevan, Commissioner on the U.S. Commission to Eliminate Child Abuse and Neglect Fatalities, stated in her article that out of all the experts involved in her panel, not one expert named the child as the client when discussing child protection laws. It is my prayer that our great state of Georgia takes steps today to continue strengthening our best interest laws for children in foster care so that children are not overlooked or forgotten. Ms. Bevan goes on to state that human development is an ongoing process that starts at birth. The importance of bonding and attachment to at least one significant nurturing adult forms the basis for emotional, cognitive, and motor development. Infants need consistent and predictable care to trust the world around them. If our laws do not reflect this, then we send babies on a long and irreversible journey filled with adverse changes in the brain, cognitive and physical development delays, social, emotional trauma, repeated abuse, and even death. When we talk about children in care, it's not a question of if they have experienced trauma, it is only a question of how frequently and the length of time that they have endured it. After many months of stability and love, these children are finding hope, healing, and stability in a foster family that loves them. In another pertinent article entitled Clinical Application of Attachment Theory, the psychologist wrote that children who are progressively reintegrated back into biological family often experience severe suffering. These children have typically become deeply attached to their foster parents, often experiencing suffering. Their symptoms express their profound fear of losing their foster parents who've become their psychological parents, their need to keep close to them day and night, and their anger and their response to the abandonment by those who have learned to trust. They have learned to trust. They said, we gradually realized that children's best interests lie in the preservation of their attachment ties, and that the rupture of such ties, especially if it is not the first one, constitute a severe trauma necessarily leading to severe short-term reactions, separation anxiety, sleeping disorders, angry outbursts, destructive behaviors, and denial of the effect. Such disruption of attachment will most probably leave important gaps in the child's character structure and in the child's capacity to establish trust-based relationships. In 2015, Governor Deal appointed a Child Welfare Reform Council in order to take a deeper look into Georgia's policies surrounding children in foster care. They advised to require expedited permanency timelines surrounding relative placement searches. This was overlooked until now. Senate Bill 167 is important for a few reasons. Most of the time, it is in the best interest for the child to remain with family members to continue their sense of belonging. But if Georgia keeps the child as our client, then requiring family members to step forward in a timely manner to honor a child's developmental attachment timeline is critical. We hope that the law will recognize that disrupting the attachment timeline is not a price our state is willing to pay, knowing that the child will most likely carry the effects of what happened into adulthood. Georgia is paving the way for other states in this country by continuing to strengthen our best interest laws for children in foster care. Following me, you will hear from some of our other foster moms who will share stories of disrupted placements and the effects it had on the children in their care, just for the sake of saying they were with family, oftentimes who are distant geographically and emotionally, never laying eyes on them. Please listen to these children's stories and use your vote to vote yes, using your power on behalf of the powerless. Thank you.
Thank you. I appreciate your comments. Next, the chair will recognize Donna Mahan. I'm going to start just referring to people in their first names. Thank you, ma'am. Welcome. Introduce yourself to the committee.
Okay. My name is Donna Mahan, and my husband David and I have been foster parents since 2010. We have adopted many children, a sibling group of 4 and a sibling group of 5 over the course of the 9 years. I am also the president of the Walton County Foster Parent Association. And I have a story of 2 disrupted placements that this bill would have helped. In February 2013, we were called to take a placement of a sibling group of 3. There were 2 older children and a 5-week-old baby. A family member was willing to take the 2 older children, but not the baby. After about 6 weeks, the 2 older children were moved to the family member, and the baby remained with us. We continued to work with the bio mom as a partnership, what they call partnership parenting. And the baby was, the first go around, the baby was reunified just before Christmas. And then in January, we were called about taking the baby back. We agreed so that the transition would be easier for us, for him, and for he'd be back with us, where he had been for almost the first year of his life. Bio mom tried to work her plan, but was not successful. By the end of November, bio mom texted us and asked if we would consider adopting the child. We told her, of course we would, as long, she told us she would relinquish her rights and that we would let her still be a part of their life as long as she was stable and doing as she should do. She told us that her parents were willing to take the older children, but that they had not passed 3 home evaluations. So we advised her to notify the caseworker that this was what she wanted to do. And we notified the caseworker the next day. She told us that bio mom could not decide where she wanted the baby placed, that decision was up to DFACS. They wanted all of the children to be placed together. So after having this child for almost 2 years, he would have been 2 in January before they moved him in December, he went to a home that had not passed 3 home evaluations. When he went and did 1 transition visit, which is all that the department did for him, he came back and it was as if he was just numb. He had blank stares. He was afraid for anybody new to come into the house. It would just really give him a hard time. He couldn't sleep. He just really had a lot of trauma. And DFACS caused that by removing this child from the stable home he had known for 90% of his life. So we were the family that he knew. Also during this time, we had another placement in our home. We had received a call asking in 2014 for the placement of 3 children that were part of a sibling group of 7. So their ages were 5, 7, and 10. We took them and they were with us for 3 years. They had come from a very abusive situation and we were their 3rd placement. They had already had a lot of trauma in their lives and they became such a huge part of our family in 3 years. They had made their desires to be adopted very clear to everyone, including our judge, and had even picked out new names for when their adoption was done. But after 3 years in our home, they were moved to family members against their will. This move created additional trauma to already traumatized children. When they first found out that a move was possibly going to occur, they all returned to behaviors that they had had when they first came to us. The then 8-year-old, she wouldn't go and play without coming back into the house every 2 minutes. Her therapist actually timed her to make sure I was still right in the same place she had left me. She could not sleep. She was afraid of everything. She began hoarding again, which, was keeping every little piece of paper. And her teachers reported that she would keep her book bag with her at all times, so if anyone came to take her at school, she could run. She was not able to concentrate in school. She would make herself literally sick and throw up in order to come back home. The oldest, then 13, was in special ed and was acting out at school constantly. She was clinging to everyone and at home would not leave the room I was in. She didn't understand exactly what was going on, but she knew enough to be afraid. Both girls had been severely abused. It was terrifying to them to think about having to move. The boy, then 10, got into fights at school, having trouble concentrating. At home, he was having problems sleeping and he was crying a lot. The week before we knew for sure that they were moving, he told us that he really did love us and that he did not want to go, but when he turned 18, he would come back and find us. He also told us all three of these children were old enough to state where they wanted to be. And they did that over and over again in the court system. Instead, they were moved. Anyway, being a foster and adoptive parent for many years, we've seen the effects of moving children. It causes so many attachment issues for their future. They wonder, how long will this family keep me? Why doesn't anyone want me? It's so sad. Our last adoption of 5 had 3 younger children that were bounced around, and we see the effects of that daily. After almost 2 years in our home, they still show signs of attachment issues. These are not easy to overcome. As president of the Walton County Foster Parent Association, I have seen this happen in many of our families. I have assisted foster parents in advocating for their rights to be heard. We need this bill so that there's a time limit for DFACS to find family and for the family to come forward. It is not fair to the children. The children in foster care are so vulnerable. They need to have a chance for their wishes to be heard and listened to. It is our duty to protect these children. In some cases, family is the right place for the children, but if the family does not come forward within a 9 to 12 month period, then their time does need to run out. These most vulnerable children do not need to stay in limbo until the DFACS or the courts decide that it really won't hurt them to be moved again. As a foster parent, dealing with adopted children with attachment issues, it does hurt them. There are approximately 175 children from Walton County alone, and approximately 14,000 in the state of Georgia. These children need to feel secure and stable. Please pass this bill quickly for our children. Please do not allow them to continue causing more trauma to our already vulnerable children. Thank you.
Thank you. I appreciate your comments. Members of the committee, do you have any questions? Thank you. I appreciate it. Next, I'm going to recognize Jill. Welcome to the committee. If you'll introduce yourself.
Thank you. My name is Jill Barefoot, and I have had the privilege of being a foster parent for the last 6 years, and 10 children have circulated our heart and homes. So this is the story of our last foster daughter. Put yourself in her shoes. You're 7 years old. You've been through a traumatic history, unstable, sexually abused, but you have been in a place for the last 980 days, nearly 3 years, where you've been able to heal, where you've learned how to ride a bike, where you've learned how to play, where you've learned how to go, you've gone to the beach, where you've learned to swim, where you've learned to feel emotions besides anger. You've graduated pre-K, moved into kindergarten, then to first grade. Then, after this time, you are told within 10 days, you are moving to a relative because they are your relative. How would you react? What is going on in your 7-year-old mind? You have to change schools, churches, neighborhoods, cheerleading teams, essentially who you've called family. All for the sake of what? How do you reconcile this? How can you, after you essentially have lost your first family, can you lose your second and recover emotionally? And who can you talk to? Our last foster daughter came to our home in November of 2015. She was a bit over 5. She consistently struggled with peers and her ability to manage her emotions. She would regularly hit, scream, bite, kick on multiple occasions on a daily basis. Upon months of love, structured behavioral reinforcements, therapy, regular routine, she was able to function day to day with her peers with minimal disruptions and began to progress academically and emotionally. She had visits with her biological mother for 5 months, but visits stopped due to disclosure of sexual abuse. At this point, the judge determined to terminate visits with the biological mother. As foster parents actively engaged in all aspects of her development, we attended all court proceedings. In a court proceeding in early 2016, we met a relative. DFACS requested that we do not allow her nor her brother to have contact with this relative due to her mother demanding she have no contact. We complied with this. However, we did provide this relative updates on milestones, happenings with her life. But after April 2016, other than a birthday text, the relative ceased communication for 17 months. During this 17-month period, our foster daughter grew well-adjusted, social with peers, and on grade level targets, academically and emotionally. By that summer, she enjoyed similar activities and camps that she had for the past 2 summers. She was excited about first grade and was beginning to participate in competitive gymnastics. After almost 2 years of living with our family, contact was initiated by DFACS to begin phone contact with that same relative who showed no interest for 17 months and who was allowed no initial contact. So after 30 months of stable, loving placement, unsupervised visits began in the community with this relative. Community visitation was stressed in court because the relative's home was not an approved placement because of past substantiated CPS history. Therefore, DFACS was requesting a waiver for the home to be approved. After living in our home for nearly 3 years, the DFACS director called me and stated that they had just received the waiver for the relative's placement, so they were requesting a less than 10-day notice in order for our foster daughter to start in a new school district. She had never had more than 4 unsupervised visits with this relative. CASA and her therapist indicated that this was not in the best child's interest. This didn't matter. It was a matter because this was our relative. Would we allow our own children to linger and not respect their natural emotional bonding timeline? Is it okay that relatives step up years later regardless of the emotional ramifications for this child? If it takes years to step up, what is the real investment for this child? Is it okay in the same home for over 980 days just on the basis of a relative placement? It is time that we expect our children in the state of Georgia to be treated as our own. Statistics do not fare favorable to our kids in this system. Dropping out of high school, ending up in jail, becoming victims of sex trafficking, it is time that we set our kids up for success. In closing, take yourself back to where we began. You're now 8 years old. You're in a new home, in a new community, a new school system with a new DFACS caseworker, and now a new CASA, a new therapist. The explanation after what you have known as your mama and daddy is that you are now living with your relatives, regardless of your feelings. Hopefully, you will be able to form healthy relationships later in life, because so far, what you've known, relationships come and go, and you're left alone. This is what happens with your first mom. Is hoping you will be okay in the future good enough? I want you to know also that 6 months later, this child that left our home asks to have visits with her mama and daddy, her former foster family. And that is how she continues to refer to us, is her mama and daddy. This bill will allow a judge to look at what is the best interest of the child, looking at their emotional and attachment natural timeline. I ask you, I beg you, to stand for these kids that do not have a voice. Thank you.
Thank you, ma'am. Members of the committee, do you have any questions? Thank you. Thank you. I appreciate it. Last to be heard on Senate Bill 167 is Shay Stevens. Please come forward. Introduce yourself to the committee.
Yes, my name is Shay Stevens. Now, I don't have as much amazing stories as they do because we've only been doing it for 3 years.
Okay, if you could just pull the mic a little bit
I'm
closer.
sorry.
Sorry, we have people watching online. So,
Okay, gotcha. My name is Shay Stevens, and I don't have like stories like they do. We've only been doing it for 3 years. But I'm just going to give my voice to hopefully help our foster daughter and how it's going to hopefully help her. We got her at 2 days old. Sorry, I may cry. But we were asked immediately from the investigator, we don't know if this family is fit. Are you willing to adopt? I mean, like right off the bat. And we told them yes. Fast forward 14 months. Family just reached out 2 weeks ago, like right before TPR. And we are like the only family she has known. I mean, she came home, you know, exposed to meth and had withdrawals. And with our 2 sons and my husband and I, we're the only ones that she knows. And she just met this family like last week. And when they do text, all they ask is for a picture, not about like her milestones or anything. So I'm just begging that this bill be passed to help, you know, for these kids to be the voice for this bill.
Thank you. Members of the committee, Representative Hutchinson.
I don't have a question. I have a comment. I've been working with foster parents for many, many years. And I have to say that next to teachers, y'all have a first-class ticket to heaven. Because I don't understand where you get your strength, but I know the type of kids that you take in, and God bless you for it, and keep it up. And I just thank you.
Thank you, Representative. Chairman Administration.
Thank you, Madam Chair. I want to thank all of the witnesses today who testified. I truly believe you are angels. You are sent by God to be here and be available for these children, and the love and care that you give as a foster parent and as an adoptive parent is truly amazing. In my law practice, I'm in juvenile court periodically, and I'm familiar with how traumatic it is removing a child from the home and from the placement that the child knows. And I can think of specific cases where the child has only known the foster environment and then is ripped out of that foster environment, causing incredible trauma. I believe that this legislation is so critically important, and I'm so grateful for Senator Brass bringing it because this needs to be done, and what's happening right now isn't right. And I think that it really comes from policymakers over years thinking that bloodlines matter more than what in the child's perspective is best. And we don't just see it in dependency cases. We see it in custody cases as well, where a third party is unable to intervene in a custody case because they don't meet one of these specific family relationships, and foster parents aren't included in those. And I'm very proud that Representative Oliver co-sponsored with me this year House Bill 543, which was passed by the House almost unanimously, that allows judges to have that discretion so that even a foster parent in a separate context here in a custody proceeding in Superior Court could seek to intervene in those circumstances, because that's what's in the child's, that is from the perspective of the child, not drawing a family tree and saying, oh, okay, you're within this class, so then you can intervene or you can't. It's from the perspective of who has acted like a parent for the child. My final ask would be, I've carried legislation in this area over several years, and I carried the fictive kin consideration legislation in 15, I believe, Director. The 15 or 16, I'm not sure. But I remember at the time we wanted to broaden it out, and that was part of the consideration, but we were very clear that the best interest standard had to be adhered to. So any of these findings in juvenile court, the judge would have to say, or by defects, it's in the best interest. And I wonder also, as we heard the testimony today, if there needs to be greater education also on the bench in juvenile court, so that there's not a belief that simply because policymakers have put in the law family members, that they believe we at the General Assembly think that that's, you've got to if there's an available family member, then that's where the child has to go. If there needs to, in addition to Senator Brass's outstanding legislation, we need to have an education component so that the court understands that it's what's best for the child, not just because you found a far-off relative, that's where the child needs to go. Then I think that needs to be considered as well.
All right. Thank you, Chairman. Thank you, Senator Brass. I appreciate it. Now we're going to move on to Senate Bill 225. And members of the committee, you did receive a substitute to Senate Bill 225. Thank you. Welcome.
Thank you, Madam Chair.
Members of the committee, just for your reference, there will be another meeting of Juvenile Justice on Monday to contemplate the passing out of House Bill 167 and House Bill 225. If there are any amendments or changes that either any of the committee members would like to see made to any of these bills, just please feel free to send them on to me. And we'll hear from Senator Walker on 225. And
thank you, Madam Chair. In February 2018, Congress passed what's called the Family First Prevention Services Act as part of a spending bill. Family First directs the way states will get reimbursed for their services, and the federal government will, for the first time, pay states for an evidence-based program aimed at keeping kids in their homes rather than placing them in foster care. It also changes the way group homes will be funded, and group homes will be really reserved for children with more severe problems, and the group homes will have to be a qualified residential treatment center. I went to a hearing this past summer that Director Rollins led for legislators, and it's a great opportunity, I think, for us to be proactive in trying to intervene early where there are problems, and to keep children out of our foster care system and out of the state's custody. So in order to do that, we need to align our state code with the new federal laws to be able to qualify for this Family First program. And that's essentially what this bill does. It also, we had to have some language in there relative to the Indian Child Welfare Act to be in compliance with the federal law on that. And then there's some notification and record keeping information in the bill too, that if somebody's been in foster care, it talks about the records that DFACS will have to provide to them when they exit foster care or age out. And then lastly, the reason we've got a substitute here is they wanted, while we were doing this, to add on line 221 through 223 the language that says it adds basically immunity from civil and criminal liability to people that notify the Division of Family and Children's Services that there's a problem with a child.
Okay, thank you. I do, for the edification of other members, I was kind of eye-rolling. I was asked to add that to the Child Abuse Registry bill, so hence the kind of eye roll. So I apologize. It wasn't directed specifically at that language. It's good language. It's obviously in great bills. So if you'll just kind of briefly walk us through, or Director Rawlings, would you like to just briefly walk us through? Members of the committee, we are working from LC 411954S.
All right, Chairman Walker's asked me to do it, and I'll be happy to. So, so sections 1 and sections 3, and also section section 4 and section 5 of the bill, as well as sections 6 and 7. This puts into state law a definition of what is a qualified residential treatment program and the procedures under which a child may enter such a program, and the procedures by which the court has to have the child assessed and must review the situation of the child on a regular basis. So what we're going to see happen under Family First is some of our group homes that now take children just because we as the agency believe that they would be well served there, are going to be limited in their ability to receive federal matching funds unless they meet this definition of a qualified residential treatment program for children, especially with behavioral health issues, developmental disabilities, who need more assistance. And so these sections of the bill put into law the requirements of that, essentially mirroring what the federal law says already. Section 2, and then also Section 8. These sections, of course we are required to follow the Indian Child Welfare Act, although we don't have any recognized federal Native American tribes here in Georgia. We do sometimes encounter children who may qualify to receive federal funds. The feds tell us we need to make sure that we have in our statutes an assurance that we will follow that law. So we wrote a very simple piece of legislation that says we're going to follow it. And finally, as Chairman Ballinger was expressing, there was a change in the Child Abuse Prevention and Treatment Act that actually went into effect midway during this session. and the change in that law says that our state law must also give immunity from civil and criminal liability, not only for people who report child abuse, but from individuals who otherwise provide information or assistance in addressing reporting of child abuse issues. So the Federal Administration on Children and Families said that to continue to receive the captive funds, which we rely on for a lot of work, we needed to quickly add this to our code. And so I apologize for the late addition of this language, but it will be helpful in keeping the federal government off of our backs, so to speak. And I'll be happy to answer any questions.
Okay, I will for the group. I know Senator Walker kind of briefly touched on that. In the state of Georgia, we are extraordinarily reliant. We're actually probably one of the top 5 states in as far as our reliance on federal dollars for our child welfare money. So we are heavily reliant on those funds, and the Families First, which we have to comply with, does severely limit our use of group homes. And I'll recognize Representative Hutchinson for a question.
Actually, I was just going to say the same thing you just said. I realize that this is a federal thing, and we're relying more on community services, but group homes and PRTFs are still necessary. And I foresee this federal legislation creating a lot of problems, and we're trying to place our most severely the children with the most severe needs, particularly mental health needs. So it concerns me long term, and so this is the new guidelines for a group home. What's in here?
It does, and I'll let Director. I don't want to overstep my bounds, but I'll let Director Alex answer.
Chairman Ballard knows this very well too. So the PRTS will be outside of this definition. They're hospitals. This actually, in a way, it actually helps because I can still use group homes using state dollars, and we'll probably continue to do so. I don't want to lose people who want to provide me with resources to care for children. But I think that what this may help us do is it will help, for example, some of our already successful, especially some of our nonprofit, larger, older group homes. If they become a QRTP, not only will they be allowed to continue to receive the federal dollars, but they'll also have a more beefed up behavioral health nursing staff. So it's, in a way, it looks worse on the surface than I think in reality it's going to turn out to be a benefit long term.
So this is creating like a hybrid between group home and PRTF?
Yes, ma'am.
Okay.
Sort of a middle layer.
And we're going to keep the group home?
Right, and then the next layer down needs to be therapeutic foster care.
Yes.
Thank you, Representative. Any other questions of the committee?
I would like to make a comment because that was my first thought too. Is I really value the services that our group homes provide and have a close relationship with the Methodist Children's Home and serve on their board and think they do outstanding work. But after hearing from the director this summer, it sounds like we're going to have an opportunity to maybe put more resources into the mental health and the behavioral health areas for the more costly children. We're going to be able to draw down more federal dollars and use our state dollars in other areas that are less costly and complicated. So I'm kind of excited about the opportunity. It is going to, anytime there's change, there's going to be resistance and there's going to be challenges, but I do think under the director's leadership, we're going to this is going to be a good thing ultimately.
Mm-hmm. And it does the new it does allow for prevention services as well. So that will be, I think, just awesome. So, members of the committee, any other questions? All right, thank you, Senator Walker. Like I said, we're meeting again on Monday at 1:30 in 515, Emily, room 515. So we'll see you then. Thank you. We are adjourned.